Welcome back from the break. Now let's head to the courts now, where the Chief of Defense Staff testified that the term misconduct does not appear in the official military release letter to Richard Jakpa. Contrarily, the release letter presented and tendered into evidence by the Attorney General cites misconduct as a reason for Jakpa's discharge. During cross-examination by Dr. Basit Bamba, the lawyer for Atoforson, the CDS confirmed he has never received a court order or any letter requesting the release of Jakpa's sack letter, referring to the widely circulated release letter signed by the Brigadier General MKG Ahiaglo. The CDS maintained that no request for such a document has ever been received. My colleague Latif Idrisu was in court today and joins me live with more. First, Latif, walk us through what transpired in court.
Okay, so the CDS was subpoenaed by lawyers for the third accused person in this case, that is Richard Jakpa, because the prosecution had attempted to question the integrity of Richard Jakpa himself. Yeah. Because Richard Jakpa had also tried to question the integrity of the Attorney General in the widely circulated audio recording. So today the CDS was in the dock. Then lawyers for Richard Jakpa, Thaddeus Sori, who is lead counsel for the legal team, who is the one who started the cross-examination. And he sought to suggest to the court that Richard Jakpa, contrary to the September 12, 2007 letter secured by the Attorney General, which has already been tendered into evidence and relied on by the Attorney General during cross-examination of Richard Jakpa, that as a matter of fact, Richard Jakpa was not sacked from the military dishonorably. So those were the line of questioning that the lawyers for Richard Jakpa sought to put to the Chief of Defense Staff when he was in the dock. Interestingly, the Chief of Defense Staff, in answering those questions, told open court today that in his line of duty as Chief of Defense Staff, he has never received any letter from any quarters whatsoever asking for him to release confidential information about Richard Jakpa or any military officer for that matter.
Okay.
That is one leg. And this is not in contrast to anything, because when the Attorney General presented his letter, which is secured from the Defense Minister, he didn't say the CDS was involved in drafting that particular letter. So you cannot make the point that what the CDS said today with regards to him receiving any official request to release letters are in contrast. What is in contrast is the fact that the CDS told the court today that the word misconduct, which the Attorney General or the prosecution relied heavily on in quest to discredit the character of the third accused person, Richard Jakpa. According to the CDS, that word misconduct doesn't appear in their release letter of Richard Jakpa.
Okay.
And that one, you would say, is in stark contrast to the letter that was procured and relied on by the prosecution during the cross-examination of Richard Jakpa.
Then where did the prosecution get that particular letter?
So according to prosecution, they got it from the Defense Minister.
Oh, okay.
The Defense Minister, so they wrote and requested for that particular document from the Minister of Defense. That brought up the question, and this was posed to him by the Attorney General, whether or not it is wrong or inappropriate for the Minister of Defense to write and release confidential information about an officer, whether it's right or wrong. The response of the CDS was that though it is not the best practice, quote and unquote, the minister can do that. Why? because him as CDS, he does not have any authority or power over the Minister of Defense. So yes, the Minister of Defense can receive that request and he can go ahead, issue and write and release that confidential information. He can copy him. He didn't say that out in court, but the best practice, he said that is not the best, but he can do it. So you would infer that the best practice, okay, let me not infer, but that's what he said. Let's report what the CDS said in court. That the minister can do that, can do what? Can release confidential information without copying him as CDS.
But shouldn't the, maybe we're asking you there, because the minister, or was that question answered in court, whether or not the minister should have to write that letter based on the information available on official document that he will use in writing that particular letter?
Certainly. So that question was asked.
Okay.
And the answer was yes. So whatever the minister put in his own documentation and released to the Attorney General was based on what the military settings made available to him about the accused person. Okay. So he didn't write his letter out of vacuum. He didn't just sit and then out of imagination he created something, but it was based on what the military provided to him about the third accused, Richard Jakpa. Okay. So it was based on that he came out with his own release information about the third accused person.
Where did the minister then get the word misconduct? Because remember, the CDS challenged that per what he has, he was not released based on misconduct, right?
Yes.
But that letter said he released based on misconduct.
Yes.
So where did the minister get a misconduct from?
So this was in a letter dated 12 September 2007.
Okay.
The last paragraph. Sorry. So I just want to read. It says,
and this is to who?
So this was from MKG Ahiagulu.
Okay.
Brigadier General. Yes, so I think it's an internal memo, if you like. So the last paragraph says that I'm therefore directed to request that Lieutenant R. Jakpa be released from the service for inefficiency under Article 15, Item 2A.
Okay.
Item 2A says, through continued lack of application or interest. And then item 2C. Item 2C says that unsatisfactory conduct of the Armed Forces Regulation Volume 1.
Okay.
So unsatisfactory conduct and then through continued lack of application or interest.
Okay.
So that was the basis on the Attorney General's claim, if I should use that word, that Richard Jakpa was released from the Ghana Armed Forces
for misconduct.
For misconduct.
Okay.
Yes.
Okay. Right. Interesting. What are the other things that happened in court today, based on the questioning and answering that happened?
So largely, it was based on Richard Jakpa's sack and all the issues that came out. Nothing really, as has been the case.
Was there a contrast between the army officer that came the last time and what the CDS came to, the testimony he gave in court today?
Not exactly.
Okay.
Yeah, not exactly.
All right then. So what is next for this case?
So the case will be called again tomorrow. We expect representation from the Ghana Ports and Harbour to show up, and one other. We are not certain about who is showing up in court, but all of them have been subpoenaed and they are expected to come in, including the Speaker of Parliament, the former Health Minister, Alex Segbefia. They are all in line. But tomorrow, it's expected that one person from the Ghana ports, and then one other person are expected to show up in court.
But we're also told of the cross-examination of the CEO for Big C.
Yes.
When is that coming off?
That was supposed to have happened, I think, last 2 weeks, thereabout. But we were told in court that he traveled to Germany and got stranded in Germany, couldn't connect to the internet and all of that, and so that couldn't happen. So that has been pushed further. And so for Big C, their date is not yet certain. We do not know when Big C would appear in court to give testimony in this particular trial.
All right. Well, let's keep an eye on that developing story and see how it travels. That's my colleague there. He was in court today and brought us a wrap of what happened in court. Now, let's take you to Germany now, because a court in Berlin has been making a pronouncement, and that court has ruled that Germany must improve its air quality standards in order to meet European pollution targets. The court ruled in favor of a leading environmental group that had sued the German government. This is one of a flurry of recent suits by activists and environmental organizations against the government's climate policies. DW's Guela South Delhi is in Berlin for us. Guela, why have environmental groups been taking the German government to court?
Well, in this particular latest case, the environmentalists claimed that the German government and its clean air quality program weren't going far enough in trying to reach European targets, but also in protecting its own citizens from pollution. And a court agreed with this assessment, even though this ruling can still be appealed. But this is only one of a series of cases that environmental groups are bringing to the courts against the German government, and specifically against its climate policies. The environmentalists believe that the German government isn't doing enough to reduce its emissions. It's not doing it fast enough. And this is why they're now taking to the courts to try to steer the government's course in a different direction. And they've already had quite some success on this front. There have been some successful rulings in favor of the environmentalists. And one famous one was in 2021 against the previous German government led by Chancellor Angela Merkel, where the government was told by the courts that they had to improve their climate policy because by continuing on their course, they were going too slow in reducing their emissions. They were actually being unconstitutional. They were injuring the right of young people and future German citizens to have a clean and safe environment to live in, which climate change would threaten.
Well, it leads one to question how Germany is performing when it comes to reaching its climate goals.
Has set some quite ambitious goals for itself. For example, it wants to be climate neutral by 2045. That means it doesn't want to emit more CO2, more carbon into the atmosphere. And we've seen some progress happening in Germany. We've seen that, for example, in the first half of this year, 65% of electricity has come from the renewable sources. We've also seen that data points to the fact that last year it was a record in Germany for new solar plants and new solar systems. So we've seen some progress there. But at the same time, we've heard from a panel of climate experts who advise the government that they say that Germany risks missing its 2030 targets for carbon emissions. And in particular, the transport and the construction sectors are too slow and are not doing enough to reduce their emissions. And this is why the environmental groups are really trying to push through the courts. They want to see more speed and more efficiency in reducing emissions.
All this as another summer of extreme climate event unfolds, not only in Germany, but across Europe.
No, we've seen again some extreme weather events happening in Europe. Just last month here in Germany, the south of the country experienced some devastating floods that caused the deaths of up to 5 people. And the German Weather Service has said that the rains that caused the floods were made 10 times heavier because of climate change. But at the same time, in the south of Europe, for example, on the Italian island of Sicily, they are experiencing one of the worst droughts in decades. Lakes have dried up. Authorities have had to ration the use of water. And these are all consequences of climate change that we see happening not just in Europe but around the globe. And this is also pushing environmentalists here in Germany to want to see more action coming from the government.